Okay, let's get started. So, today we have an incredibly important conversation hosted by Cynthia Santiago. Cynthia is going to be covering the latest immigration news, policy updates, the essential terms, concepts, best processes, and practices for non immigration attorneys to understand. And so, Abogada Cynthia Santiago is the daughter of immigrants from Oaxaca, Mexico, and Guatemala. At an early age, she witnessed injustice resulting in her brother's wrongful incarceration. She developed the passion to defend the rights of her community. Abogada Santiago has been a community activist for more than 2 decades, raising awareness of social justice issues and establishing 2 teen centers focused on combating the school to prison pipeline. In 2012, immediately after being sworn in, she began her own practice focusing on immigration and criminal defense. Through deportation defense and representation, she gained vast experience in complex crimination cases. She is known for her grassroots community outreach that has assisted hundreds of families throughout the U.S. and border. From 2020 to 2024, she became host on national TV show Tribuna Jurídica, where she provided legal insight and breaking news on immigration topics to a Spanish-speaking audience. Abogada Santiago has a passion for leading others to higher education. She has sponsored various scholarships and hosts mentoring events for first-generation students. In 2020, Abogada Santiago branched into personal injury and workers' rights to further assist our underserved communities in knowing their rights. Abogada Santiago served on the CAOC Women's Caucus and as trustee for the Mexican American Bar Association. She is a powerhouse, and we are incredibly grateful she is taking the time to educate us. So, without further ado, Cynthia, please take it away.
Hi, thank you, everybody. So we're just having, we could post up the slides, I guess, now. Mikaela, thank you so much.
Yes,
And
of course. And is the camera, the link, a little funky?
no, there's just no link to camera. Yeah,
Okay.
because I entered it as an attendee, but that's fine. If you just want to post the slides up, we'll go from there.
Okay, perfect.
Thank you so much.
Yes, of course.
So what we've been doing most recently since January is just educating folks about what's happening with immigration. Week by week, things are changing. And it's just a situation where it is important for us to be able to adapt to these changes, to familiarize ourselves with immigration, and not necessarily consult folks, but to have a resource available that you can rely on in case your clients have an issue that comes up. So I've been very, very grateful that a lot of firms have reached out to me, and organizations have reached out to me to do these Know Your Rights presentations. And as I mentioned, they keep changing. So every week I have to kind of update what's happening. But let's go ahead and get going with all of this info. And I don't expect anybody to become an expert in immigration law over a 15-20 minute Zoom, but it's definitely somewhere to get people started in their firms to start implementing these practices. So one of my biggest advice right now in this situation for non-immigration attorneys is that in your intake process, have some type of way to start determining the client's immigration status. I know it might be an uncomfortable question, but it's important that you let the client know that these things do they do matter in the situation where you want to make sure that if they might qualify for something, they could talk to an attorney, or if their family members need assistance. And what we're thinking is, like, just in an intake process, it's important to know at least the client's immigration status, their immediate family members, and potentially any witnesses in your matter. If their witnesses are, complete strangers and whatnot, then it might be an uncomfortable conversation. But for immediate family members, it's important. If one of the plaintiffs is facing a deportation and then their family member is unable to recover, then this is something that, it should be addressed sooner than later. Educating clients about their rights in civil matters. It's important that clients know that they still have the right to pursue claims. If there is an employment claim, if there's a personal injury claim, they have these rights. And in California in particular, these rights are even more protected by our state. Encourage language access. So language access is very important when we're talking to our clients, interpreters that are fluent in the language, not using their family members to interpret. And just the fact that there's also a large in LA County, for example, in California as well, a large indigenous population, indigenous languages are spoken. And so I'm talking about indigenous folks from places like Mexico, indigenous folks from other countries, and there's a gap in the amount of information that you can obtain from families if there isn't a proper interpreter. Encourage clients to engage with their consulates, going to their consulates and requesting a passport, a consular ID. Those are important also when you get to the settlement stage and they need to maybe they need to cash their check or they need to put their money in a bank account. These documents are important for them to have sooner than later. A lot of the consulates right now are also making efforts to help people find the right resources in their situation, immigration situation. Familiarity with immigration relief and benefits, such as the U visa process, a T visa, VAWA, family petitions. I'll go ahead and discuss these a little bit further, but when a client is, for example, a victim of a type of employment violation or an assault in terms of a battery assault, sexual assault, then there's that potential civil case may turn into an immigration case because they either reported it to authorities, they were victims of this type of abuse. And those are ways for them to also collaterally get an immigration benefit from their situation. VAWA and family petitions are more based on their family members, like meaning they were victims of abuse by their spouses or their adult children, or family petitions. So these are things that I'll go ahead and discuss in further slides, but it's important for us to understand at where the client kind of stands in the immigration world. Have a trusted immigration attorney to consult and connect with. A lot of firms, a lot of personal injury firms are reaching out and they're setting up appointments for clients that are going to have potentially a trial coming up or that they're concerned about their status and they have a lot of questions. So this is important to just always have somebody that you can count on and maybe set up their appointments or do these Know Your Rights trainings to your staff and team. I recently wrote an article for Mikaela's Advocate. It is in the March edition. I can go ahead and Mikaela, maybe we could send a link or something to those who'd like to read it, but it's an Advocate article from March of this year about how personal injury attorneys and civil attorneys can help their clients who are undocumented.
That'd be awesome.
Thank you. Next slide is. So what we want to do when we first assess whether a person has status or no status is we're asking or we're looking as attorneys, we're looking as immigration attorneys, particularly I'm looking at whether that person has had a prior order of deportation. Prior orders of deportation can occur at the border where they were maybe detained when they were trying to make entry or they were returning back to the US after having left the country. And if they were detained by an immigration officer after 1997, there was a change in the law that allowed an immigration officer at the border to give them a deportation. It was called an expedited removal, or it is called. And so this process is one where they don't have to see a judge and they won't be able to see a judge if they've already had a prior deportation order. Typically, they would be booked in and sent out of the country unless they're from, depending on what country they're from, it could happen within hours or it could happen within weeks. But a person that has had a prior deportation order would be either from the border or from an actual judge. The next case of individuals that are being removed out of the country kind of immediately without a chance to see a judge are people with aggravated felonies. I see this a lot with individuals who have like drug convictions, individuals who have serious felonies, the individuals that are being picked up from the prison. This is something that has happened for many years. Once a person is eligible for parole, I've seen ICE within, prior to this administration, pick them up from where they're being released and put them into deportation proceedings, have them either sign deportation or leave the country. And this is also something that affects legal permanent residents. A legal permanent resident cannot have an aggravated felony, or they're subject to getting their green card removed and being deported. Individuals with denied asylum cases. These are individuals who have seen an asylum officer and they've determined that they do not have the requirements for asylum. They are referred to see an immigration judge for deportation. These are cases where there is no, there's just no, it's an automatic referral to the judge for deportation if your case is denied. Denied immigration cases, recently, the policy has shifted that if your immigration case is denied, so you're applying for your spouse and you're trying to get them a green card, if that case is denied, they will refer you to an immigration judge under the new policy that was announced this year. Criminal history, including misdemeanors. We're talking about individuals who maybe were arrested for domestic violence, battery, or DUIs. Now we're seeing a lot of enforcement with them being picked up from their home or because a probation officer reported them and they're being sent to immigration facilities. In various counties, there was rules where immigration was not allowed to be in the county jails. We're seeing a rise in agreements between local officials and the ICE officers, and being able to now give them access to those who are detained for misdemeanor crimes even, or even just pending charges. They don't even have to be convicted of a charge. And so what we're telling folks, especially in the criminal world, I work a lot in crimmigration, is that they should hire a crimmigration attorney. A crimmigration attorney can go into the I'm finally here, Mikaela. An immigration attorney can go, sorry, a crimmigration attorney can go into the court and they can represent their client without them having to be present. We're seeing the importance of that right now because we're seeing this wave of detaining those who, like, for example, the judge who had a criminal case allegedly and had the client or the person leave the courthouse. So it is important if your client has some type of a criminal history or they're like an arrest for no license, even a misdemeanor arrest, that they should be talking to a crimmigration attorney as well. Those with pending immigration cases with immigration, there's somewhat of a risk. As I mentioned, if their case is denied, they will get referred to immigration court. And then those individuals that have no immigration case pending, they've never been detained by immigration in the past, they have no history with immigration. I will get to the slide where now there is policy where they would have to report themselves and do a self-reporting under the Trump registry plan. Next slide. So it is important as attorneys that we have a baseline of where the client stands. Are they a permanent resident? That means they have a green card. That means that they have status. They are able to come in and out of the U.S. But as I mentioned, they're also able to be to face deportation proceedings. And they're able to face deportation because their permanent residency is not a citizenship yet. Conditional residents are individuals who either married a U.S. citizen and they have a special condition on their residency because immigration wants to avoid fraud. So they require them to stay married for the 2-year period. If they are not married, they have to demonstrate that their marriage was bona fide. They would have to demonstrate that maybe there were some type of abuse within the marriage, and that's why their marriage did not stay together. And so this conditional residency is also kind of something that can be taken away. And if the person does not properly file the documents needed, they can be referred to an immigration judge. The other place where people can be is they can be DACA holders. They can be DACA recipients, TPS recipients, or special juvenile status, or they can be in deportation court currently. That means that the individual technically cannot be taken out of the country because they're still in core, or they have some type of a deferred action program, which basically has them protected to some degree. I am protected in quote unquote, is what I say. Adjustment applicants, Visa U or VAWA, are individuals who are in this middle area where they still don't have their documents, their case is still pending, and they're at risk that if they are detained, they would be put in front of a judge, or they can be taken out of the country if they've already had a deportation on their history. A visa holder, as long as their visa has not expired, they are generally okay and safe. Although we've been seeing a rise of visas being revoked for students. We've seen a rise of visas being revoked for people who have an arrest on their history. Visa holders as well. The situation with visa holders is that they have to leave the country during the time period allotted for them before the time period expires. If they don't, then they're overstays, and they are also subject to being deported or put into deportation court. Those awaiting for a pardon from immigration or an asylum interview, those are individuals who are also in limbo because they do not have a status. And these petitions take many years. For somebody who entered the US without permission, and they're married to a US citizen or a legal permanent resident, they go through a 3-step process to get a green card. And I have a slide that describes this process later on. And when they're in this process, they have no status, and they have to wait to go abroad to their interview to get status. Or as an asylum seeker, they have no status until they have their interview and are granted asylum. So these individuals are basically with no status, waiting for processes that usually take a minimum of 4 years. And they can't get a work permit, they can't get any type of relief under, well, those waiting for asylum can, but there's certain areas and gaps. No immigration status are individuals who just have no status at all. So this is why I'm saying this, these charts, these different categories are so important to know where your client stands, because there's no one size fits all. The Know Your Rights advisors are really a good baseline, but every single person needs to have an assessment done either through the nonprofits, through an attorney, because every single person needs to be able to assess if immigration shows up at their door, what will happen? What will happen to them? Do they have the right to see a judge or not? Okay. Mikaela, can you get the next one? It's a little. Thank you. These are things that have changed as of 2025. DHS expanded expedited removals. When I spoke about people who received deportation orders at the border, this was a policy in place for many, many years, since 1997. At this point, as of January 2025, it has been expanded to include the entire United States. The entire United States, meaning that if an immigration officer sees someone and they believe that person has not been in the US past 2 years, they can detain them, and they will basically put them into proceedings to not proceedings, but just in an expedited removal process to deport them from the country. The person would technically have to carry person would technically have to carry proof that they've been living in the US for 2 years. They would carry maybe like rental receipts or some bank statement, some type of documentary proof that they've been in the US for 2 years so that they can overcome that presumption. If not, then that person will be determined to be a expedited removal, and they take them out immediately without seeing a judge, unless they can request asylum. So these are things that like clients have to be prepared to know if they fall into this category. What do they say? What do they do? And how do they stop something so fast from happening to them? Next slide. This other policy change that happened this year was a directive that enforcement actions can happen in and near protected areas. Previous to this administration, there was certain areas that were deemed protected: churches, schools, courts. Now, an ICE officer can conduct an enforcement action in or near a courthouse if they have credible information that leads them to believe the person will be at that location, the undocumented individual that they're searching for. This is something that we are trying to adapt what happens in California, for example. I think it's important for us to talk to our, our attorney general. I think it's important for us to talk to our representatives and to talk to our court directors to see whether they will be taking on what they will do in these situations where ICE is able to go into the courthouses. I have not seen this happen yet, where they go inside the courthouse, this here in LA, but we have seen recent stories where the judge was arrested. And this is where I have seen ICE, though, outside of a courthouse. I have seen ICE waiting for someone to leave the courthouse if they knew they had a hearing that day. So this is something that we really have to kind of pull all the resources together and figure out what is the policy and directive that California or certain local courthouses will take. Next. This is the Trump registry plan in a very short, condensed version. Immigration is now, USCIS is now requiring that those over the age of 14 go online and do a registration process where they will put in all their details, where they live, their date of entry, who they live with even. And in this registration process, immigration has not, they're not keeping back into saying that they will use this information to enforce immigration. And they're making it very clear that they will use this to target folks for arrest, detention, and deportation. As an immigration attorney, we're having a really difficult time telling folks what they should or shouldn't do in this situation as a whole, but we're asking folks to have individual consultations because there are many individuals who may have already registered when they applied for a work permit or a green card or some type of immigration process. They may have already been in the system. But this is a very frightening plan or registry situation because they're basically asking folks who are undocumented to carry this registration that they registered, to provide all their information to immigration, where they live, who they live with. And if they don't, they will face criminal and civil penalties. It is now a legal requirement. Unfortunately, there's a slide from a few weeks ago, but this is something that is frightening because I think what immigration was seeing is that they were having a difficult time doing mass deportations as they were threatening to do. And this would basically require, then this has been a law for many years in the past, but it wasn't implemented. And this would basically require a person to self-deport. Next slide. These are the general advisals that we've always seen online, that we see a lot, that we've been hearing a lot about. Is telling folks that they generally don't have to open the door if ICE comes to their home. They don't have to consent to an entry. They can contact a rapid response hotline or an immigration attorney. If they have an immigration attorney that is maybe on retainer for them to try to help guide them through what happens, what's happening in their home. Everyone should have an emergency plan ready. Families should, talk about what happens if ICE comes to our home, who's going to be the point person if in case they do take somebody from the home or outside of the home, who's going to contact an attorney, who's going to um, start making all the arrangements to figure out where the person's being detained. Um, I've I've been telling folks when I'm doing my Know Your Rights in different communities is that they should also talk to their neighbors. If they trust their neighbors, that people should be on a community chat or community, some type of a way to communicate if there is suspicious individuals outside of their door. There is usually unmarked cars that show up and they come to the front and, they're wearing documents that say, or vests that say police, or sometimes they'll identify themselves as ICE. So it should be kind of a community collective coming together to support each other in case they do see some suspicious activity outside of their door. Usually these detentions are also in the morning. They're at 5, 6 in the morning to kind of get people when they're not as, active or alert of their front door. Next. I've also talked to different employers and people who have, are afraid that if they get detained at a workplace, and at workplaces, generally there's a public and a private area. And, if a person is in a private area, ICE does not, they don't have permission to go into that area unless they have a warrant. And we're always telling folks that if they have coworkers or their employer, people can take video, take notes, contact the rapid response hotline. It's always good to document these situations, these detentions, because if it was done, without an official warrant and they did violate someone's rights, then we are able to use that to argue that in our immigration case and and eventually sometimes there's been cases where we are able to get the charges dismissed, if we have a good judge on our side as well to see the illegality of those kinds of detentions. So, at workplaces, it's always important to have an emergency process in place as well if ICE does enter the workplace. Next one. See. There is a very important website called ILRC. It's the Immigrant Legal Resource Center. They have a 21-page packet in different languages for families. If there's mixed status families, they have a list of important documents. They have a child information questionnaire. They also give like a temporary authorization template for families that are mixed status and are afraid that they will get deported, the parents will get deported, and the children will not have a caregiver. There are temporary ways to have someone authorized to be there in case of an emergency for your children. And that way, a lot of these families are having to face this harsh reality to have an emergency plan. And this this packet is really good at providing all of that information. Next one. Yes. When talking to clients, it's important you see, if they're married to a citizen or a resident, they potentially can file for a case. They should speak to an immigration attorney. A lot of times it depends on how they entered the US. As I mentioned before, if a person's a victim of a crime or a victim of abuse by their spouse who has a green card or is a US citizen, They can also potentially get immigration benefits without having anyone petition for them. It's a self-petitioning process. There's also cases where I've seen personal injury cases where there's children involved, minor children who have no status. And there's a special juvenile status for those individuals who are under 21 in California, for example, to get a green card under a self-petition. If they are victims of abandonment, neglect, or they just have one parent, they cannot return to their home country. All these things can be discussed, obviously, with an immigration attorney to assess if you have a client in that particular situation. There's students with DACA and TPS holders. They're able to, they're still able to continue to travel with an advanced parole. It's an advanced permission from the government. This process has not ended, but it is very tricky because we have to get it done before there's any changes to this policy. And they have to be screened. They can't leave the country without a proper screening because they might be not allowed reentry in the US. There's also individuals who might be able to apply for asylum, or they might be able to have a petition available in court if they're facing a deportation proceeding. So just because you're in deportation proceedings doesn't mean that you'll be deported. There's a lot of cases that we're able to get people granted status because they're in deportation proceedings, or that we're able to get these cases pushed out enough that we probably end up in a different administration that will allow us to close these cases with administrative closure. So there's a lot of things that still, like, there's still hope in these situations, but only an immigration attorney can really assess what your client in particular will have. Next slide. And just to give an example, and we're running out of time, but just to give an example, say visa entry with someone without a visa. If someone enters the US, they had a visitor's visa approved, they entered the US legally, they have a US citizen spouse, they file for residency, within 6 to 9 months, they get a work permit, an interview done, they get approved for legal residency, maybe in under a year, and in 3 to 5 years, they could file for citizenship. However, someone who was not able to obtain a visa in their home country and they enter the United States without inspection, meaning they cross the border through the desert, through hidden in a car, whatever method, and they're not able to get a visa entry in, they marry a US citizen, they have to first file a petition that is called a family petition. It takes about 1 to 2 years. They don't get a work permit and they have no status. They get approved for that family petition. If they've only entered the US once, it was the first time that they entered and they never left, they would have to file a waiver. Because if they leave the country without filing this waiver and getting it granted, they're subject to a 10-year ban. They cannot come to the US for 10 years. Then that person, if they file this waiver, it's pending for 2 to 3 years. They're here in the US, they're waiting for their work permit. They get no work permit, they have no status, they're waiting for their approved waiver. Once their waiver is granted, they file documents to get a consulate interview done in their home country. They wait another 1 to 2 years, they still don't have a work permit, they still don't have status, and then they go abroad for their interview. And if they're approved, hopefully they return in a few weeks. But this process is about a 4 to 6 year wait. It's like a big difference between when folks say, well, it's just easy for people to get their papers. No, it's not. It's a real big hurdle to get their documents unless you enter with the visa or you have some type of a petition that you can do in the US. It's a very long process. Next. Briefly, if your client was a survivor of a crime or workplace violation, as I mentioned, there's a U visa process. It does take several years, but it is important if they have been subject to that and there's a investigation or a police report available that they speak to an attorney and they get an assessment to whether they can qualify for a U visa. Next, let's see. And I want to leave time for questions. Right now, our biggest defense in this time is to litigate, to file file cases against the government and challenge these orders, challenge these policies, continue to advocate for our clients, continue to be vocal about what's happening. And I think that, that we just have to keep fighting back. A lot of these things have also we've been successful at getting a lot of these programs. Also, the courts have sided with a lot of the challenges that we've done. And so I think that it's important as a community of advocates to support these efforts. I think we mentioned, Mikaela, I mentioned that I wanted to talk about like immigrant defenders. They represent, here in Los Angeles, they represent thousands of unaccompanied minors. With this administration changes, they've lost a lot of funding. And so they need a lot of support, immigrant defenders. There's also organizations like the ILRC who's producing this information, reliable information. Right now, we're being saturated with a lot of these TikToks and these Instagram videos that kind of are creating more and more fear onto the community. They're very, 15 to 30 seconds can't define what immigration laws are and what immigration policy is. So it's important for us to support organizations that are doing this responsibly, like the Immigration Legal Resource Center. And then also just supporting your clients in finding the right reputable attorneys that are going to be honest about their situation. Next is, I think, just my contact info. Mikaela, we can do questions too now, if you want.
Yeah, perfect. Let's do it. I'm looking in the chat, and I know we have a couple from Bob. And then if anyone else has any questions, definitely feel free to drop them in. But the first question we have is, can you speak to the reality of people trying to get their citizenship over the past decade and how hard it truly is?
Yeah, I mean, that one chart that shows like what the time difference is with someone who entered on a visa versus someone who didn't enter on a visa, who entered without permission, that's what we face. We face years and years of a process for someone to want to do it the right way. The whatever the quote unquote right way is. The other situation is that since 2001, there hasn't been a significant like change with immigration law. 2001 was the last time there was a program for those who had those who had petitions available for their parents who are legal residents or citizens, or from their brothers and sisters. And that allowed people to pay a penalty. It's called 245I, and it allowed people to pay a penalty of $1,000, and they would not have to leave the country to get their green card status. That case, like that situation hasn't happened since then. So if anyone has a petition after 2001, it's many years of waiting and having to leave the country. So 2001 was one of the last times we saw big like immigration change. But also to even look at those lists of visas. For example, if you're from Mexico and your brother or sister is a US citizen and they petition for you, the wait time is about 25 years to get a brother and sister to petition for you. And even then you have to leave the country. So there's just not enough happening with immigration, the Congress and acting on immigration laws to give us a very permanent solution. We're getting a lot of, programs like deferred action, TPS. TPS holders they've had that program for about 24 years. And they still don't have green cards, unfortunately. So there's just a lot of programs that also are not leading us to a permanent solution.
Do you have a sheet or something to tell all of our clients what to do if they find themselves in this situation?
Well, as I mentioned before, it's just so hard to do a one size fits all for everyone, because you say you have a client that has a green card. Well, they wouldn't be necessarily facing a deportation. They would present their green card information, and they immigration would have to they would have the burden to show that that person is deportable. Whereas a person that has never had an immigration process, their immigration deportation process is going to be different depending on how they entered, depending on if they were detained at the border. If, as I mentioned before, if a person was detained at the border, then they're subject to being removed within hours. If they're from Mexico and if they're from another country, it's within the amount of time it takes to fill a plane that will take people back to whatever country they're from. And so it's just it's not a one size fits all. I do have resources though from the ILRC that talk about know your rights. Those are good baseline. I think those are really good places to start with, but every single person at this point, and they should have, a lot of people should have done this for many, many years as attorneys. We should always be looking at these issues, but to just assess where the person stands and have like a plan for an individual plan for that person and their family in particular is probably the best thing that could happen. I also tell a lot of folks this idea of immigration going to everybody's house is, um, you know, it doesn't seem possible because of their lack of resources, but they're doing it now in the way of registry. They're threatening folks that if you're not registered, you're going to be facing criminal charges or facing civil penalties. And so that's where our individuals need to know where they stand and what they can do in their particular situation.
I don't see any more questions in the chat, but I definitely have a few for you in the last 13-ish minutes that we have for this webinar. I know you touched a little bit on this, but what is the current state of immigration law and how much has it changed even in the last 2 months?
I think I have video now. Yes,
Hey!
I have video now. Um, So as I mentioned, like immigration law hasn't really changed. It's the policy that changes with every administration. And in this administration, what they're doing is that they're looking at laws that have been in the books for a while, and they're using those laws to enforce immigration. So the Alien Enemies Act is the idea that immigration the federal government has a right to detain somebody simply because they're in the country without a status, and they're going to be deemed an enemy of our country. And so that's what they're doing. They're finding these really old laws, and they're starting an administration policy that is targeted to a lot of folks in this country who maybe don't even have a criminal record. And like we've been seeing this lately. And so the mere fact that they're in the country without permission is why they're calling them criminals.
So, for undocumented folks that are having legal problems, do you recommend that they not pursue court claims in this current climate?
No, I think that as attorneys, we really have a big task to educate folks that they still have the right to pursue their claims. In California in particular, and the article I wrote for the advocate, there are California-based laws that will protect the status. It's protected information. And so this should help the client feel a little more comforted that they're going to be okay if they file their claim, that their status is not of an issue, and they have the right to file their claim. So it's our work to kind of be know your rights mini advocates for our clients in every particular situation, because we do think that people should file their claims and people should pursue the right to that. And the only way that they will understand that they're going to be okay is if we're telling them, like, under California law, they cannot check your status on that. They cannot use it against you. Also, we're telling folks that that are in current cases, that in most of these cases, they're not required to go to court unless it goes to trial, right? Mostly, Mikaela, yeah. So a lot of times the work is going to be in the pre-lit stages, and they're not, because I think a lot of folks fear is that they're going to be in court and that ICE is going to show up. And so that's another area where doing the best we can to get remote hearings and depots and things like that done so that clients are not having to face a courthouse where they're fearful that they might get detained.
You touched upon this a little bit, but we have personal injury attorneys and some employment attorneys signed up right now. And so, for those of us who have clients that are undocumented and in active litigation, are there any steps that we can be taking?
As I mentioned, just their status, knowing where they're at, talking to them about their particular immigration history, letting them know that that information is confidential and privileged. And so then they're able to share that freely, but it helps us assess whether that person should, what steps to take in those cases. I've heard of judges recommending to do protective orders, but you don't necessarily, the defense doesn't necessarily know about your client's status unless they use other methods to kind of get that information. And we would just push back on them obtaining information about the client's status or about their social security number, things like that. Those who do employment law, I think it's a little bit more difficult for you to, for the employment attorneys, I think they are required to disclose like social security and like work information and whatnot. So, same thing, just having your client be assessed and doing your best to get these cases taken care of and settled before their client has to face any court actions. And if they do, I mean, that's, preparing your client. If a person's going to go to trial, they should have an attorney, an immigration attorney that they've consulted with and we talked about, and we go through a plan. And then sometimes even like if there's a threat that immigration might show up, then that attorney's available with like an authorization on a retainer that if they have to step in and, the person's being detained, that the attorney can step in to try to stop a deportation. Although, for the most part, if a person has not been in proceedings, they've not been in front of an immigration judge, they don't have a deportation order, then as long as they follow the steps, like I will not sign for a deportation, I want to speak to a lawyer, I want to call my family, I want to see the judge, then those are the steps that are taken to put them in front of an immigration judge. And that usually an immigration deportation case takes anywhere from 5 to 7 years in Los Angeles County. So the person isn't immediately taken out if they've never had a history. Again, case by case, but yeah, if the person has had a deportation history, the person has been in proceedings, they were already given an opportunity to see a judge, those are the individuals that really need an attorney to be on call in case they have to file an emergency stay of deportation so that they are not taken out of the country.
We also got another question. What about someone who is getting petitioned by their child and has entered with advance parole?
Those are usually, advanced parole is usually considered a visa entry. So it would follow the steps of adult child petitioned by visa entry. And if everything goes well, they do the process here in the US, and that's usually granted within a year. However, one local office in Santa Ana is taking the position that those cases are on hold. So we're just telling folks to continue to renew their DACAs, renew their work permits, and that way we can get through this hurdle of what's happening with those cases if they're going to process them normally like they used to. And that's something that like an advance parole entry is the equivalent of coming in on a visa. It's been a huge benefit, but I think what we're seeing with this administration is that they're just trying to get us in every angle possible, and we just keep fighting back.
I think we have about time for one more question. So, over these next 4 years, what should we be doing as as a profession to positively impact the immigration space?
Yeah, I recently spoke for the CAOC group for the org, and I think that it's important to continue to have conversations with immigration attorneys, to continue to invite immigration attorneys to conferences, to continue to have panels on these issues, to continue to support immigration organizations and attorneys, because as I've been in practice for 12 years, I've had my own firm for 12 years. I've seen variations of immigration enforcement. When I first started, ICE was set up in the jails. They were set up in facilities where the person would maybe have like a no license, a ticket, a suspension, and they would end up in a full-blown deportation proceeding for something so like you literally could pay a ticket or go get a license. And so like and clear it up, but that person would end up in a full-blown immigration deportation proceeding. And this was something that was allowed back then, and we've made various efforts. So as attorneys, like we continue to advocate for our clients, continue to tell our representatives, our representatives in lobbying efforts to protect our clients in California specifically and other states. It's a lot of the bigger challenge. And I also encourage folks to help out organizations that are outside of California. Places like Florida, Texas, they're being hit really big with all these enforcements, Colorado. And so I think that as a profession, we continue to have conversations where immigration is a topic, not just because right now we're seeing it in our faces all the time, but it's something that's always been a problem with folks that are really just doing the best they can in in society and working hard and taking care of their families. And this is a situation that's been ongoing. So continue to educate and support.
Thank you so much. And I see one more question in the chat. I don't know if that's something that you would want to talk about now or personally with this person. It says, is there another form for I-864W? My daughter is petitioning for me as to change my status, but I have the 40 credits and I don't know how to prove.
Yeah, no, that would probably be like more individualized situation, just because I'm not sure what other petitions are being filed and the history, but yeah, go
Yeah,
ahead.
so I would
I
direct that
contact-
person definitely to your contact, which should be still up on this slide, I
Yeah,
believe. Yes, I see my screen still sharing.
thank you.
Yeah, and I'm gonna make sure that that is all of the chats. Yeah, awesome. I can't thank you enough, Cynthia, for your time and your education and all of the work that you were doing. And for everyone that signed up, thank you for wanting to show up and make a difference in this space as well. So I appreciate everyone. If you have any questions, definitely check out Cynthia's Instagram and then also email her where her contact is right there.
Thank you. Take care, everybody.
Thank you, everyone.